Hello students, welcome to ABHI Law, where law is simplified. This is your Professor Dr. Ambarish R Patnigere, and in our lecture series on the Indian Evidence Act, previously we have completed chapter 1. Today we are going to start chapter 2. Chapter 2 starts from section 5 to 55. Now this is very important chapter and a lengthy chapter, but we are going to discuss everything in detail. Before we start the chapter, let's discuss two important terminology. The terminology is relevancy and admissibility. When we talk about relevancy, we should know what is relevant. Relevant is defined under section 3 of the Indian Evidence Act. What is relevant? Relevant is nothing but one fact is said to be relevant to the another when the one fact is connected with the another fact as per the provisions of this law. That means if one fact is connected to the other fact as per the provisions of this law which is mentioned in this section, it is called relevant fact. So now we have understood relevancy, we will understand admissibility. What is admissibility? Admissibility means that the fact which are relevant and the court has agreed to admit or inquire such fact. This is called admissibility. Now where admissibility is defined? Admissibility is properly defined under section 56 and some few other sections. All admissible facts are relevant, but all relevant facts may not be admissible. Now why like this? Because there are many facts which may be relevant, but the court may not allow it to get admitted because it is the court time is very precious. Hence we should understand that all admissible facts are relevant, but all relevant facts may not be admissible. Now there are certain exceptions. Certain exceptions are section 91 to section 99. Exclusion of oral by documentary evidence. Section 115 to 117. Exclusion of evidence of facts by estoppel. Section 121 to 130. Exclusion of privileged communication such as confidential communications with a legal advisor, communication during a marriage, official communication. Section 25, confession made to a police officer. Section 89, insufficiently stamped document. Section 122, communication made by one spouse legally wedded to another. Section 126, professional communication, communication made between the advocate and the client. To understand relevancy and admissibility, two important case laws we are going to refer. One case law is Ram Bihari Yadav versus State of Bihar. Here Supreme Court in this case observed that more often the expression relevancy and admissibility are used as synonymous, but their legal implications are distinct and different. For more often than not, facts which are relevant are not admissible. So all facts which are admissible may not be relevant. Next important case law is Lakshman Das Chhaganlal Bhatia versus State, AIR 1968. Here the court has laid down certain important points regarding relevant fact. Facts necessary to explain or introduce a fact in issue or relevant fact. Facts which supports or rebut an inference suggested by a fact in issue or a relevant fact. Fact which establish the identity of anything or person whose identity is relevant. Facts which fix the time and the place at which any fact in issue or relevant fact happened. Facts which shows the things or parties by whom any fact in issue or relevant fact was transacted. In these two important case laws, relevancy and admissibility is clearly explained. Now we should understand which is first, whether relevancy is first or admissibility is first. This is a very important question. Before we answer this question, let's look to section 136, which gives the power to the judge to decide the admissibility of the evidence. It plays a very vital role, important role here. The essential ingredients of section 136 are: the judge will decide the questions of relevancy and admissibility. When a party proposes to present evidence of any fact, the judge may ask the party to clarify in what manner the fact would be relevant. The judge would admit the particular presented fact only if he is satisfied with the answer of the party that it is indeed relevant under one of the provision of section 6 to section 55 of chapter 2. Hence, what is relevant gets admitted. Not all relevant fact may get a chance of getting admitted. Though admitted, if not relevant, it is the wastage of time. Court time is very, very important. It should not be wasted. Hence only relevant and admitted fact needs to be presented. We will study the difference between relevancy and admissibility. This is one of the important statements which we have studied about relevancy and admissibility. Now we will differentiate between the two. What is basically the difference? Point number 1, relevancy. One fact is connected to another, it is called relevant. So this is the meaning of relevant. In admissibility, facts which are legally admissible under Evidence Act are admissible facts. Now, second difference, section 3 gives the interpretation of the word relevancy, and relevant facts are mentioned in section 5 to 55. Admissibility is defined under section 56 and the sum of the following sections. The third difference is relevance is the cause, admissibility is the effect. Fourth difference is the court has discretionary power when we talk about relevancy, but as far as admissibility is concerned, the court has no scope of applying any discretion. Fifth point, all relevant factors may not be relevant, but all admissible factors are relevant. Point number 6, connected to facts, relevance is connected to 5 senses, and the 6th is the psychological sense, means what we can perceive in our mind. Everybody knows 5 senses when we discussed about fact. Admissibility is totally based on law. 7th is relevance is to prove or disprove the fact. Admissible is significant to admit such fact in a particular case. Next difference of point between relevancy and admissibility is relevancy is concerned to the extent of relevancy only, but admissibility extends to both relevancy and then its position pertaining to admissibility. Point number 9. Relevancy discusses what is relevant. Admissibility limits certain relevant facts to. Last point is governed by logic and probability, and admissibility is strictly governed by law. These are the 10 points which will differentiate between relevancy and admissibility. I hope so. If you can write all these 10 points, you will definitely get full marks when we distinguish between relevancy and admissibility. This was one of the important university questions which we have discussed. Again, we will revise. We said about relevancy, section 3, we talked about admissibility, section 56, we talked about 2 important case laws. The important case laws were Ram Bihari Yadav versus State of Bihar and Lakshman Das Chaganlal Bhatia versus the state. If you write these 2 important case laws, I hope so, you will be able to score the right marks in the exam when you approach relevancy and admissibility. With this, I hope so I have made you to understand the terminology of relevancy and admissibility. If you have liked the content, if you have liked the video, please give a like, share it with your friends, subscribe to the channel of ABHI Law. If you have any important comments, please send your valuable comments to abhilawcomments@gmail.com. Thank you.